Hello, I'm Professor Sir Bernard Ricks and I conduct a course called Transnational Commercial Problems. I designed the course in order to cover the international aspects of English commercial law. My background is that of a barrister who became a judge, ended up in the Court of Appeal in England and Wales, and after my retirement there I became an international arbitrator, which is where I spent most of my time. But I also became a judge in the Court of Appeal of the Cayman Islands, and I'm still a judge of the Singapore International Commercial Court. I do a bit of mediation, and I teach at CCLS. Now, my course is meant to give you a sort of synoptic view of English commercial law, particularly from an international point of view. I begin with some discussions of principle and pragmatism, and the role of precedent in English commercial law, and the difference between a law such as the common law, which is based on jurisprudence, and a law like the civil law, which is based on codes. And I go to contract interpretation, and I contrast contract interpretation as practiced in the common law and the civil law, which gives a greater bite and understanding to problems of contract interpretation. And I always tell my students that contract interpretation is the real center of commercial law. So in various areas of the law, you'll be taught lots of principles, but they all come down to contract interpretation. And then we go on to deal with some of the basic principles of commercial law, such as the importance between conditions, any breach of which may bring a contract to an end, and in nominate terms, only important breaches of which by reason of their consequences might bring a contract to an end. And how else are contracts brought to an end? By frustration, by cancellation clauses, and so forth. Then we look at problems of misrepresentation, innocent, negligent, and fraudulent, and the problems that they arise in the contractual sphere. Looking at problems of international law, we look at sovereign immunity as a defense to a claim. Many sovereigns and their public companies are litigants in commercial areas. And we look at a particular common law doctrine called the Act of State doctrine, which is a defense to a claim, not by reason of the person of being sovereign, but by reason of the function of doing a sovereign transaction. And then we look at particular areas of international commercial law, such as sale of goods, shipping, which is so interesting, and insurance, which raises very interesting problems. Then we look at a problem of good faith. The civil law has an overriding public order doctrine of good faith, which supersedes even what the parties have agreed in their contracts. English commercial law dislikes the uncertainty which such an overriding doctrine introduces into the parties' bargain, but it nevertheless tries to deal with problems of good faith by specific individual problems. And then we end up looking at the differences between litigation, arbitration, and mediation. What are their virtues and what are their vices? Yes, also their vices. At the end of the course, I hope you will have had a synoptic understanding of English commercial law, which will help you in your other courses, and I look forward to seeing you if you choose to take this course.